VP 我哋個 Vice President Loli Chung 咧就會主持下一個環節嘅。咁下一個環節咧就係關於呢一個響呢一個禁足嘅期間咧，作為業主咧有啲咩可以做同有咩唔可以做嘅嘢嘅。咁咧，Loli 你喺唔喺度？咁亦都 Oh yeah, I will hear you. Once again,
okay,
thank you so much, Mike. Thank you so much, Brian. I appreciate for your time. And Loli,
thank you, Brian.
Go
thank
ahead.
you, Mike. Okay, great. Hi, everybody. So now we move on to the next session in our CREAA Expo series. So our topic is the do's and don'ts for landlords during the COVID-19. So I know that there's a lot of landlords out there and many questions, especially with tenants and rents, etc. So today we're very fortunate to have two guests, Tiffany Yee and Olivia Doppler, and they're two top-rated attorneys with Stephen Adair McDonald and Partners. They are San Francisco law firm. So from 4 to 4:30, Olivia would speak to us, and then at 4:30, Tiffany will speak to us. So Olivia, are you with us right now?
I am, yes.
Olivia? Oh, great. Hi, Olivia. Please introduce yourself, and then we go on, and then we have a question and answer session a little bit later. Thank you so much for being here today.
Thank you for having me. So my name's Olivia Doppler, and I'm an attorney with Stephen Adair McDonald and Partners. We are a real estate litigation firm in San Francisco. We deal with various types of real estate litigation matters. My practice primarily focuses on landlord-tenant disputes. So for example, I represent a variety of landlords in residential matters, commercial matters, unlawful detainers, rent board hearings, and that kind of thing. And then Tiffany, did you want to go ahead and introduce yourself too?
Yeah, so my name is Tiffany Yee. I'm also an attorney with Stephen Adair McDonald and Partners. And like Olivia, my practice generally involves representing landlords in disputes with their tenants, particularly fault-based and no-fault evictions. So we're actually going to a little differently. So I'm going to go ahead and get started. There were two hot topics that CREAA wanted us to cover today. So I will go ahead and just jump right in. So as we all know, as a result of the global pandemic, the state and local governments have issued a lot of rules and orders, including the shelter in place and eviction moratoriums. These rules are changing day by day. So we will go over what this means for San Francisco landlords for the rules that are currently in effect as of today's date. So as everyone knows, Mayor Breed issued the shelter in place, and that expires May 3rd. Residents are required to stay in their homes except for essential activities. So serving an eviction notice is not an essential activity. Mayor Breed has also issued an order prohibiting all residential evictions for 60 days after the prohibition order expires. That order was recently extended, so it will expire on May 22nd. 60 days after that date is July 21st. The exceptions for this rule are evictions based on violence, threat of violence, or health and safety issues, or the Ellis Act. So what this means is you can still serve an eviction notice after the shelter in place order is lifted on May 3rd. For example, a 60-day notice, so long as it expires after July 21st. If any landlord proceeds with serving an eviction notice during this time, there is a handout on the rent board website that you must include with the eviction notice. Now, a lot of you are probably on to hear about what to do if there is a non-payment of rent. So for non-payment of rent evictions specifically, if the tenant misses a rent payment that should have been paid due on or after March 13th, 2020, the landlord cannot evict the tenant if the tenant provides within 30 days of the rent being due that they are unable to pay the rent due to financial impacts of COVID-19. This could be extraordinary medical expenses, or it can be lost wages due to reduced hours, layoff, or business closure. Within 1 week of letting the landlord know, the tenant must provide written documentation to explain why they cannot pay rent due to COVID-19. A letter explaining why is sufficient documentation. They do not need to provide you with pay stubs or any confidential medical records. Now, the tenant will have at least 6 months after the order expires to pay the rent in full. Landlords at this time cannot charge late fees, interest, or other fees. The landlord can request documentation that the tenant has an ongoing inability to pay, but if the tenant cannot provide this documentation, or for example, if the tenant notifies the landlord in 31 days, 35 days, it's not going to be enough to evict them on that reason alone. So just to be clear, the tenants still owe this rent, but the deadline to pay is extended by 6 months. If you already have an existing eviction case that is already filed with the court, the San Francisco Superior Court has issued a rule that these cases are on hold and will be paused until June 19th, 2020. Now, on the state level, California was declared a state of emergency on March 4th by Governor Newsom. He issued a similar order prohibiting non-payment of rent evictions. So even if your property is outside of San Francisco, there are similar rules in effect. Another important rule on the state level is the California Judicial Council issued emergency rules for unlawful detainer. That's just another name for eviction lawsuits. Unless you have a case related to health and safety, the court will not issue a summons for your case until 90 days after Governor Newsom declares an end to the current state of emergency. A summons is required to start any eviction lawsuit. So basically, even if you serve an eviction notice at this time, you cannot start the lawsuit to enforce the notice until 90 days after the state of emergency. This is important because once an eviction notice has expired, a landlord cannot take any rent from the tenant. So your tenant will be living rent-free for that time. So for people who are considering 60-day notices, you may want to just wait until the state of emergency has ended or there's an announcement as to when it will end. So what does that mean for people right now who have tenants who are not paying rent? So for example, if your tenants have not paid March or April rent, they still owe you this money, but they're not required to pay you now. They have until 6 months to do so. The most important thing you can do right now is to communicate with your tenants and try to work out a rent repayment agreement. If they give you partial rent payments, you should take it. But we do recommend that you give the tenants a letter saying that acceptance of partial rent is not waiving the outstanding balance due. If the tenants have a third party who wants to pay rent on their behalf, you are required by law to take those payments so long as a third party provides a signed document stating that the third party is only paying the rent and they are not asserting any tenancy rights. So if you do agree to a rent repayment plan with your tenants, but 6 months later they are unable to keep up with the agreement, then at that time you can start a non-payment of rent eviction lawsuit. However, if and when you are able to evict for non-payment of rent or any other just cause reason, just keep in mind how a judge or jury will view your effort to evict a tenant during this time. And then finally, if tenants are interested in moving out or breaking their lease, You can also engage in buyout negotiations with them or simple move-out agreements for the tenants to move out without a formal eviction. If you do decide to do that, just make sure you do visit the San Francisco Rent Board website to follow the rules about buyout disclosures and filing any buyout agreements with the Rent Board. So Olivia now will cover briefly how this impacts commercial non-payment of rent. And then there was also another hot topic submitted to CREAA about temporary evictions and how that works. So Olivia will cover that.
Thanks, Tiffany. So Tiffany just covered the residential eviction moratoriums that are in effect in San Francisco. San Francisco also has a commercial eviction moratorium that's in effect right now as well. It relates to non-payment of rent cases only. It's currently in effect until May 17th. However, it's already been extended once by the mayor, and it's certainly possible that the mayor could end up extending it again. As it's currently set up, basically this is going to cover the April and May rent payments for most commercial tenancies. Again, if the shelter-in-place orders are extended further at the state and local levels and businesses are unable to open in May and potentially even into June, it's definitely something to look out for to see whether or not the mayor goes ahead and extends this order to cover additional months of rent beyond just the April and May rents. The commercial eviction moratorium is pretty similar to the residential one that Tiffany described for non-payment of rent. Obviously, it's applying to commercial tenancies, not residential tenancies. It does only apply to certain types of businesses. It would apply to businesses that are registered to do business in San Francisco, and businesses, out of those businesses, it has to be ones that had worldwide gross revenue of under 25 million for the 2019 tax year. So for certain larger businesses, this would not apply to them, basically. Like with the residential moratorium, the tenant has to document that their inability to pay rent is related to financial impacts of COVID-19. It's fairly simple for the tenant to do that. Basically, the commercial tenant can send a letter or an email to their landlord explaining how their business was impacted by COVID-19. And the tenant can keep redocumenting this. With the way the moratorium is set up, the landlord and the tenant are supposed to work on a payment plan, but if the landlord and tenant are unable to come up with a payment plan, basically the commercial tenant can keep recertifying the inability to pay each month, and they can basically get up to 6 months to repay the rent. And during that time period, the landlord's not going to be able to evict the commercial tenant for non-payment of rent. Like with the residential moratorium, the tenant still owes that money. It's not waived. It just delays the time period that the tenant has to repay it. And the moratorium doesn't prevent the landlord from taking other types of legal action. So for example, if the landlord's going through a really hard time and can't pay their own bills, they could consider bringing a small claims action or other types of legal action. They can't evict for it, basically. A little bit different than the residential moratorium, there is a hardship process for landlords in which basically if they are having a significant financial hardship, they can request a waiver from the moratorium from the Office of Economic and Workforce Development. And basically they would have to show that they're going through an extreme hardship because they're not receiving these rent payments. The Office of Economic and Workforce Development does say that those applications will be highly scrutinized. So unless there's some sort of extreme hardship, probably the landlord won't get it. But perhaps if they can show that they're unable to pay their mortgage and maybe they're at risk of being foreclosed upon on their property, perhaps the city would allow them to continue on with an eviction anyways, give them basically that hardship waiver. We just talked about eviction moratoriums. I did really quickly also want to mention that there is a rent increase moratorium for residential properties in San Francisco that's also working its way through the city right now. And basically that would prevent residential landlords from raising rent on rent-controlled units during the period of the moratorium. That has been signed off on by the Board of Supervisors, and last I checked, I was still waiting for the mayor to sign off on it, but it will be retroactive to April 7th, assuming that the mayor signs it. So that's another thing to be careful about. In addition to these eviction moratoriums, you need to be careful about trying to raise the rent at all right now in San Francisco. And also just to note, you know, we've been talking here about San Francisco laws, but many of the other Bay Area cities, including Berkeley, Oakland, other cities over in Alameda have similar moratoriums in effect right now as well. So, I mean, basically with everything that's changing so much right now, you know, just a good thing to keep in mind is that you should reach out to a real estate attorney if you're considering starting any sort of legal action. And as Tiffany mentioned, just try to work out deals with your tenants right now. Basically working out payment plans or entering into buyouts are gonna give landlords options that they would otherwise not have because the courts are not handling these things. Okay, so as Tiffany mentioned, we've heard that another thing that a lot of people have questions about right now is the temporary eviction process in San Francisco. And for those of you who are unfamiliar, the San Francisco rent ordinance allows landlords to temporarily evict tenants in order to do capital improvements or rehabilitation work on their units. And then when that work is done, you need to notify the tenant that the work is done so the tenant can reoccupy. In order for a landlord to qualify for this type of eviction, they need to be doing work that makes the unit unsafe or unlivable. The landlord then needs to provide the tenant notice that they're temporarily terminating the tenancy, and they need to have the tenant move out while that work is being completed. So in general, this is going to require that a landlord provide the tenant with a 60-day notice to move out. The landlord does have to pay the tenant relocation money as well. There's a daily rate for displacements under 20 days and a flat rate for longer displacements. The landlord needs to get all necessary permits to do the work before terminating the tenancy. And if the work is expected to take more than 3 months to complete, the landlord actually needs to get permission from the rent board in order to displace the tenants for more than 3 months. Also, oh, go ahead.
Oh, Olivia, I was just going to say we have a lot of questions. So I wonder if we can just start going through all the questions because it looks like we're pretty short on time.
Sure.
So the first question is, what's the status on the AB 828? Is that moving forward or how's that coming along?
Tiffany.
AB 828 regarding to the reduction in rent amount, tenants rent amount.
At the state level?
Yes, at the state level.
As of last we've heard, it's something that's been proposed. It hasn't been passed yet. It's another one of those things where these laws are changing constantly, so you definitely want to keep an eye on it, but as of right now, we haven't seen anything passed on that.
Okay. Let's see, the next question here. Let me see, there's so many of them. Let me go back to the beginning.
I actually copied and pasted the questions if you want me to just go through all of them.
Okay, that'd be great if you can.
Okay, so we had someone asking about if a tenant does not pay March and April rent and ignores you, should a landlord provide a notice to pay rent or quit? So you're not supposed to be issuing notices to pay rent or quit at this time. So it is on you to contact the tenants and to give them notice that they do need to talk to you and to come up with a payment plan. And just know that you do have this 6-month window that essentially you can't do anything to pressure them to pay. You can't really Even if they ignore you, there's nothing really you can do about it. So it's important that you document to the best of your ability as a landlord as to how you are trying to accommodate the tenant, so that later, if they still don't pay after 6 months, you have the documentation you need to start a non-payment of rent case. What if the rent was due on March 5th? It's going to be the same thing, because right now you can't do anything in court anyway. So just continue to document and your efforts to be reasonable with the tenants and to come up with a payment plan. And just understand that after 6 months, if they really have not paid, then that's when you can take action.
Oh, did you want me to finish? So I do see a question here about can a commercial tenant request for a rent reduction? As we discussed, there's the moratorium right now on evicting commercial tenants. And as part of that process, again, the landlord and the tenant are supposed to work in good faith to come up with a payment plan. And the guidelines that were set forth from the Office of Economic and Workforce Development do talk about basically the types of agreements that landlords and tenants can come up with. And one thing that is mentioned is not just delaying the payments, but potentially actually having the landlord reduce the rent or take less rent during this time. So that's definitely something that the tenant can request, but the landlord is not required to agree to that. If the landlord wants to agree to that in order, maybe, say they want to keep this commercial tenant in business because they know that getting a new commercial tenant could be costly or take time and they're going to lose out on rent during that time period. That's something they could agree to do, but they're not required to do so.
Olivia, there was a question, are landlords allowed to increase the rent based on the San Francisco Rent Board annual percentage during COVID-19?
So again, that depends on whether or not the mayor signs off on this rent increase moratorium, but it's looking highly likely that she will. It did pass through the Board of Supervisors, and she's been passing other, quite sweeping measures right now, including the eviction moratorium. So I assume that she is going to sign off on that if she hasn't already. And in that case, basically, then no, a landlord right now would not be able to impose those annual increases or any banked rent amounts that would otherwise be available to them right now. They don't lose out on them, they just can't impose them right now, basically, is the way that the moratorium is set up. And again, this is retroactive back to April 7th. So unfortunately, trying to rush and get a notice out now won't really do you much good because it would be for any rent increases since April 7th.
If a tenant provides proof that they have been furloughed, what should you do? Should you send a forbearance form? What can a landlord do to get ahead of unlawful detainer lists since the courts may be clogged up? So yes, you can send a rent forbearance form or just any type of communications with your tenant that they, as to some sort of rent repayment agreement. And then in terms of trying to get ahead of the courts, unfortunately, this is unprecedented. We don't know what the courts are going to look like once they do reopen, just because the existing trials, existing cases are delayed. So any new cases will be at the back of the line. So we have heard that some firms are proceeding with filing the unlawful detainer complaints so that they have filed the paperwork that they can, and then they will just wait until the courts start issuing the summons to get their case moving forward. There's a question here about an Ellis Act and when a law firm should get involved with an Ellis Act if there is insurance counsel currently involved. So just very briefly, if anyone does an Ellis Act, you need an attorney to do this. There is just so many forms that are required that you have to make sure it's sent to the tenant, make sure it's sent to the rent board, So it's very difficult for someone to do it on their own. So I do recommend that if you are even contemplating an Ellis Act, that you consult with an attorney right away. And the Ellis Act is always going to be separate and apart from any insurance matter. So if you have insurance counsel, they will never touch anything related to an Ellis. So it's completely separate, and you should treat it as a separate matter. It looks like, Olivia, are you familiar with the commercial properties in LA?
I don't know the commercial rules in LA off the top of my head. Unfortunately, you know, since we primarily practice here in the Bay Area, I haven't studied the LA rules in detail. You just have to keep in mind that basically Governor Newsom said that local cities and counties could pass moratoriums during this time period if it's related to COVID-19, and a lot of cities are doing that. I mean, just generally speaking, I've heard that there are several in Southern California that are in effect as well.
So I do just want to remind everyone that the information provided today is not legal advice. You know, we can't advise you without knowing your specific facts of your specific property. And everything is based on the rules that we know of in effect today, April 24th. As we mentioned before, everything is constantly changing, and it's hard to predict where it's going to go day by day. But please do feel free to contact Olivia and I after this presentation if you need assistance with your specific property, or if you have questions about different counties. Our office is open during this time, and our attorneys are working remotely, and we can offer a free 20-minute consultation by phone or email. We don't offer flat rate for eviction cases, for unlawful detainer cases, but we charge by the hour, and the rates, I believe, Olivia, are $350 to $495.
Yeah, I think that's correct. And I see a question here about whether we do the 20-minute consults by phone or email. I mean, primarily, especially as an initial matter, we would do that by phone generally, just because it's easier to get the information that we need from you in order to help give you the best advice if we can have a back-to-back. You know, you can definitely email us as well, though, and then, you know, if for a particular reason we need to do something by email, we can accommodate that as best as possible, you know, and just go from there.
Well, thank you very much. The information that you guys have provided is very helpful and very valuable. I wonder if you guys can put your individual contact information in the chat room, so that anybody else who have additional questions can contact you directly. Would that be okay?
Yeah, that's no problem.
Great. Thank you so much. I think it's time now to turn over to the Chinese portion of this. Victoria, are you with us?
Yes.
Oh, okay.
Yes.
So we can start the Chinese version.
係，大家好嚇，我哋美國華人實業協會今日好高興有 Tiffany Yee 同埋 Oliver Doppler 嚟到我哋呢一度咧，同我哋解下喺呢一個疫情嘅期間，如果你嘅租客唔能夠負擔得起租金，咁係有啲乜嘢應對嘅方法嘅。咁其實頭先咧我哋都有提到，咁或者 Tiffany 你再簡單好 briefly 咁樣講一次。
In English?
Yeah.
Okay. Okay, so the mayor issued the shelter in place to expire on May 3rd, and you cannot leave your home except for essential activities. And so that does not include serving eviction notices.
OK，好好。
Can you translate, Victoria?
吓？
Can you translate, Victoria?
我頭先其實聽得唔係好清楚，呢度有一個 I got a little breakout。
Okay, so how about I give it a try in Chinese and then you help me out
OK。
best you can. Okay? And I don't know how to say mayor in Chinese. Sorry, so. Okay.
Just say it one more time in English.
Okay. All right. So Mayor Breed issued the shelter in place to expire May 3rd. So you are required to stay home unless you need to leave for essential activities, which does not include serving eviction notice.
Which do not include, right? OK， 咁我哋嘅市長咧係因為有而家呢一個shelter in place， 即係一定要留喺屋企嘅命令底下咧，而呢一個 shelter in place 嘅命令咧係直至到5月3號為止嘅。咁樣咧，所以咧大家呢段時間咧都係唔可以走來走去嘅。And Tiffany?
Mayor Breed also ordered that you cannot evict for 60 days after the order expires. This applies to residential evictions.
5月30號之後數落去嘅60日咧，都喺嗰段期間咧，我哋都係唔容許係驅趕你嘅租客，不管佢有冇交租嘅。Am I right, Tiffany?
Yes, and the eviction expiration date is July 21st, so you cannot evict until that time.
即係話咧，7月21號之前咧，都係唔可以提交呢一個驅趕租客通知書嘅。So you are saying as you cannot even serve any eviction notice to tenants before July 21st.
So actually, you can serve a notice, but it cannot expire during this time. It has to expire after July 21st.
咁即係話咧，如果目前咧係有租客唔交租，喺呢個情況之下咧，你已經係做緊一個驅趕租客嘅程序與否都好，咁喺7月21號之前咧，佢哋都係唔可以被驅趕出去佢哋而家嘅物業嘅。Does this include commercial space?
Olivia, is this commercial the same date for commercial?
The commercial eviction moratorium is in effect until May 17, but what it effectively does is give tenants up to 6 months after a May rent payment is due to pay their rent. So it's slightly different.
Commercial means, can you give me an example of commercials like restaurant, dentist, office?
Exactly. Any type of rental that is not someone living in the unit. So it would be absolutely restaurants, office buildings, malls, shopping centers, any of that type of thing.
咁律師樓嘅 Olivia 就話咧，喺5月17號之後咧嘅6個月咧，佢都係唔可以驅趕你走嘅。如果你係租緊嗰個地方係做商業用途嘅話 ，Then what about 6 months later, like after 6 months followed by May 17, do they have to pay it in lump sum?
So for the commercial eviction moratorium, yes, after their 6 months ends, then everything is due. And if they can't pay it, then at that time, the landlord can go ahead and evict them for non-payment of rent. So the full amount would be due that's past due.
6 months after May 17, should we understand as it is November 17 this year?
Yeah, so around that time period, correct.
So they can keep their business running until November 17.
Yeah, keep in mind that that's just the current expiration date. It has already been extended once, so it may get extended again.
即係話，如果你係 commercial 嘅物業咧， 你租嚟做緊生意，但係你冇辦法交租喺呢一個時間咧，咁樣都係可以留到去2020年嘅11月。就喺呢一個時間裏邊咧，你個生意都可以照常營業，縱使你係冇交租咁樣咯。但係去到11月嘅時候咧，你就要一次過將啲租金交晒出去俾個業主噶啦。如果唔係咧，個業主就可以係驅趕你走噶啦。Okay, so during November, if the tenants still not paying the rent to their commercial space, what will happen after that?
So at that point in time, the landlord could serve a 3-day notice to pay rent or quit, kind of what they would do, before the whole COVID-19 pandemic started. And what that is it's an eviction notice. It requires the tenant to pay in that 3 days. And if they don't pay, the landlord can move forward with an eviction lawsuit.
Okay. 咁如果你咧去到11月咧都係俾唔起咧，咁佢哋就會可以提交個趕你哋走嘅通知，咁就通知你要離開呢一個商業物業，唔可以再喺呢度做生意啦。咁可能分分鐘咧係3日之內你就到時就係要走㗎啦。Okay. Okay, let us see if there's any questions. Let me repeat a little bit of the previous questions. So, someone is asking that he has a property with a few units, and there is a fire before. So he claimed insurance, and the insurance has covered all the loss, and the property has been totally fixed. So now, how do he invite the previous tenants to come back?
Yeah, so as we kind of cut short a little bit earlier in the presentation, I was talking about the temporary evictions. The laws in San Francisco provide that when the landlord is finished with the work, they must immediately offer the units back to the tenant to come back.
How? Mailing letters, phone calls?
Yeah, so it should be in writing, definitely. The rent ordinance states that the landlord must advise the tenants in writing as soon as the work is finished that they can come back. And there's basically a mailing provision in the rent ordinance. What it says is that if the tenant gave the landlord a mailing address, you first mail it there. If the landlord did not get a mailing address from the tenant, then you need to check and see if the tenant put anything on file with the rent board as far as a mailing address goes. And if there's nothing on file there, then you basically want to send it back to the unit that the tenants were living at, plus any other known addresses for them. And that would include email addresses.
For how many days? Like I have to wait for their response for how many days? 60 days?
Yeah, so first of all, the landlord needs to make sure that they file a copy of that offer for the tenants to come back with the rent board within 15 days. So basically they're showing the rent board that they complied, that they gave the tenant that notice. That needs to be done again within 15 days of the landlord sending out the offer. And the tenant has 30 days from when they receive the offer from the landlord to decide if they want to come back.
Okay, let me explain it. 所以咧，你如果係已經係個物業完全整好晒之後，咁你係需要邀請翻你以往嘅租客入嚟住嘅。咁咧，你係會有15日嘅時間，即係整好之後嘅15日咧，15日內你就馬上咧係要去寄信啦、電郵啦，以文字嘅形式咧通知你舊有嘅租客，話俾佢聽咧，而家物業整好，佢哋有權翻入嚟住。咁呢一個文檔咧，亦都係需要擺去 San Francisco Rent Board 嗰度咧嚟到作檔案嘅，即係你都要話俾佢聽你有咁樣做到嘅。然之後咧，你就等30日，15日過去之後，再等30日睇下對方有冇回信話想入翻嚟住啦。What if they say yes, they want to come back? So are
Good question.
we the same rent?
A good question. So they have to then actually reoccupy within 45 days of when the landlord sent out that offer.
要45日之內翻嚟啦。如果佢哋係想翻嚟嘅話 ，what if no response from the tenant at all?
Well, if there's no response, then they didn't accept the offer to return. But I would, basically, I think the landlord wants to really double and triple check to make sure that they notified the tenant correctly, and that they didn't somehow miss one of these steps.
咁咧，如果佢哋冇 response 咧，你就其實最好嘅做法咧，就係再俾少少耐性同埋時間咧，去再聯絡佢哋，去確定你自己嘅聯絡方法咧係正確嘅，唔好喺呢件事情上面擺烏龍。And what about if they has no response at all for the next 60 days?
Well, I think at that point, then they've missed their time to reoccupy. So the landlord, again, as long as they follow the correct steps, then the landlord would be within their rights to just go ahead and rent that unit to somebody else. But again, I think they just want to really double and triple check that they followed everything correctly, because otherwise the landlord could risk that it would be deemed, potentially a wrongful eviction. So, again, there are several steps here. So I would recommend that the landlord, for one, check the information on the San Francisco Rent Board website. There is actually a lot of helpful information on there. There are a few detailed handouts on that website that go through these steps, but then also probably just if they receive no response at all from their tenant, I would recommend that they check in with a real estate attorney just to, again, double check that they follow the procedure correctly before re-renting to somebody else.
如果租客咧係冇任何回應嘅話咧，當然咧你就係可以將你個物業重新放上租務市場嗰度出租啦。但係最好咧，你見佢哋唔回應嘅時候咧，都應該去揾一個律師樓去詢問你做嘅程序。當其時你邀請佢哋翻嚟嘅時候，有冇搞錯或者甩漏咗任何嘅一個環節？咁樣咧，律師行嘅人員咧係會比較熟悉，所以佢哋可以幫你，就好過你自己去咁樣做嘅。So what if the case if all tenants comes back because the rent is very good back at the old time, so everybody comes back. So, and then after they come back, can I do an Ellis Act and trying to get back the property?
Yeah, Tiffany, did you want to answer that one?
First, going back to the notice, there was a question about contacting them by phone. So if you do have the tenant's phone number, yes, of course, try to call them. Just try to contact them any way that you know how to make sure they receive the written notification. You can give them a call, let them know you're about to send them something and what is the best way to get them a written letter. So if you do have their phone number, do call them first before you give up.
So 我想問下 Tiffany， 如果你有一個住客咧，佢唔俾租金咧，3月份啊，或者4月份啊，或者5月份咧冇俾租咧，咁你應該可以做到啲乜嘢咧？呢家？
So you can reach out to them and talk to them to see why they have not paid rent in March and April. They will probably say they lost their job or they have medical expenses or something like that. So it's important to try to come up with a repayment rent agreement so that within the 6 months, they can repay that back to you. If they don't follow the agreement after agreeing to it, then after 6 months, you can start a non-payment of rent eviction case against them.
Victoria， 你想唔想重複一次嘢咧？我話 Tiffany 就話，如果你最好咧就同個住客傾偈咯，睇下可以幾時還翻嗰個租金。咁咧，如果佢真係6個月後唔俾租金咧，咁你就嗰時先可以開始一個 unlawful detainer 嘅 case， 啱唔啱啊 Victoria？
個問題就係咧 ，Tiffany landlord 係幾時先至可以 file 去啲 credit bureau 嗰度話呢個租客有 late payments 嘅咧？要超過幾多個月唔交租，業主先有權去 report 佢嘅 credit 咧
？That would be when you start the unlawful detainer action. I mean, technically you can do it sooner, but it's usually when you start the unlawful detainer, because they won't be able to, you know, follow through with that until you actually get a judgment for that rental amount.
即係話咧，如果個租客唔交租咧，你就要去file 一個，即係要去申報一個係非法進駐嘅條文，而法庭都判咗你係啱，佢係冇交租啦。喺呢個時候咧，你先至可以向信用報告公司提供呢一個租客真係冇交租嘅資訊俾佢哋嘅。
So going back to the Ellis Act question, if the tenants after a fire, they do come back at the low rent, and you want to exit the rental business, meaning you don't want to rent anymore, then you can start an Ellis Act eviction for the whole building. But it's important to remember this applies to the whole building, not just 1 or 2 units. And it involves relocation fees that you will have to pay. And it's a 4-month notice, but most tenants will get that extended to 1 year.
OK， 咁咧，你如果佢哋係翻嚟住，你都可以用 Ellis Act 攞翻個物業啦，但係就要係全個大廈有幾多個單位都要全部一齊申請，即係全個一齊攞翻晒嘅。但係你哋要知道佢哋租客咧，可能係會有1年嘅時間可以繼續喺度住。但係個問題係咧 ，Tiffany 啊，佢係想問幾時可以開始，即係話譬如我啱啱先至invite佢哋翻嚟住，咁我可唔可以即刻又話我而家想要做 Ellis Act 咧？即係話如果個 case 就係我知道我要叫翻啲租客翻嚟住。但係咧，其實我又知道我會申請 Ellis Act， 咁可唔可以 simultaneous 咁樣去通知個租客？你贊唔贊成咁做咧？即係以前嘅租客。
So let me involve Olivia on this question. So Olivia, the question is, if the tenants have been displaced by fire, you know you have an obligation to invite them back. But in the back of your mind, you know you want to do an Ellis Act. When should you start the Ellis Act? So I know prior we've seen landlords start the Ellis Act while the tenants are displaced. I just don't recall if they've changed that since.
I think it can get really tricky if you're trying to do it that way. It becomes difficult to serve legal documents in the appropriate manner, and leaves questions as to where you need to send notices, and really even whether it's appropriate to send them notices to terminate that tenancy when that tenancy is actually temporarily terminated right then. So I would say ideally, to have a clean eviction, you would wait until the tenant has actually reoccupied to do an Ellis Act eviction. But if you know for sure that that's in the future, you might want to try to approach the tenant before they move back in to do, and then you're planning to do your Ellis Act eviction, maybe share those plans with them and try to find out if maybe they're interested in taking a buyout or something like that to avoid all the moves back and forth. In other words, you try to work out some sort of deal with them where they give up their rights to return via a buyout agreement, making sure, of course, that you've complied with San Francisco's buyout laws.
Ah, 係啦，咁如果你係心裏邊已經知道你可能將來會做個 Ellis Act 咧，最好咧就係上去律師樓同律師傾下咧，因為咧本來都有一種叫 buyout agreement 嘅，就係話你可以同租客去協調，如果你唔再 嚟翻呢一度住，你有啲咩賠償會俾翻佢。咁咧呢一樣嘢咧就唔可以私人同個租客傾嘅，你就要拜託律師樓去做呢一個事情啦咁樣。So Olivia, well, go back a little bit to the commercial questions that we have. What if, okay, what is the consequence if the business owner really cannot afford the rent? So what can the landlord do to a commercial renter in this case? Is that only get unlawful detainers and get them out and call credit bureau? Or what will be the consequence? Will it subject to fine or jail to the renter?
So are we talking about during the moratorium period or afterwards?
Afterward.
Afterwards.
After
so
November.
Yeah, so after the 6 months has run out. So at that point in time, there are not criminal ramifications for not paying your rent. You know, assuming that we're talking about a non-payment of rent issue here and not some sort of other eviction that might have criminal ramifications. Generally speaking, a landlord's not going to be able to pursue any sort of criminal action against the tenant, but they could still go after them financially. It's not just a matter of getting the tenant out of the property, and the tenant is still legally on the hook for that money. So the landlord could also get basically what's called a money judgment against the tenant, and potentially try to go after the tenant to if the tenant has other types of assets, to try to collect on those. Depending on how the tenant business is set up, that could get complicated. You know, there are other methods of collecting on judgments as well, such as garnishing wages and that kind of thing. But again, that gets tricky when we're talking about businesses versus individuals.
係話咧，你嘅 commercial 啊，你商業嘅業主咧，都係可以通過法庭嘅途徑咧，係獲得一個 judgment 啊，即係一個叫做法庭頒布嘅結果，俾嗰個業主去繼續追討呢一筆欠債。佢可以由你嘅私人財產嗰度追討，但係咧係好視乎你簽約嘅時候咧，用咩形式同佢簽約嘅，你係個人啦，係定係一個譬如有限公司啊咁樣，所以呢啲情況咧就可以問下打電話去律師樓，講清楚你自己嘅背景同埋同個商業鋪位嘅業主嘅關係嘅時候咧，先會得到詳細嘅答案㗎啦。係咁我哋喺 Tiffany 喺右邊咧，我哋仲有個問題就係咧
Yeah, so about the Ellis Act.
No, what about the building is mixed use? Can you just do Ellis Act on the residential and not the commercial units?
Yes, the Ellis Act is only for residential units. So if you have a mixed use building, for example, you have 2 residential units sitting on top of 1 commercial unit, then if you do the Ellis Act, it is only on the 2 residential units. It does not affect the commercial unit.
係啦，咁即係可以嘅嚇。住宅單位咧就去申請 Ellis Act， 但係咧樓下嘅商業鋪位依然都係可以繼續出租嘅。So Tiffany, are you required to invite the tenants back if the lease expired during the rehab stage?
Yes, so that's one of the biggest confusions for landlords, is that even if you have a fixed term lease, meaning it is only 1 year long or 6 months long, that lease will automatically renew after it expires. And so unless the lease says it will renew for the same amount of time, it will renew as what is called a periodic tenancy, which goes month to month. So if the lease expired during the rehab stage because it was a fixed term, it will automatically renew. And so they do have that right, they still have the right to come back.
即係話就算咧物業喺重建或者裝修嘅期間咧，合約到期啦，但係咧喺三藩市嚟講咧，如果你 到期咗之後咧，其實咧佢哋都係會有一個每一個月嘅合同嘅，就等於其實佢哋係有合約喺度，所以佢哋都係可以係有權繼續喺度住咯。Are you suggesting forbearance agreement with tenants at this time？ 你會唔會贊成咧啲業主咧去同個租客簽個即係可以延期去交租嘅一啲協議書咧？
Agreement, any type of agreement with your tenants at this time is a good idea, just so everyone is on the same page. It also shows if later you do start a case that you try to work it out with your tenants and that you try to accommodate them. So if it's called a forbearance agreement or a payment plan or any type of correspondence, it is a good idea to start that communication with your tenants.
咁佢就係話咧，其實喺呢個期間，如果你嘅租客係冇交租，你又想同佢簽張紙正正式式話好啦，我俾你延遲褪後幾個月交，你總共係欠我幾多錢咁。咁呢一種咧都會係好嘅，即係你同佢有一個白紙黑字係大家傾偈過，有啲咩內容咧，其實都係對業主係一個好處嚟嘅。So Tiffany, are you suggesting forbearance agreement with tenants at this time for tenants who aren't paying rent? What if the tenants will not agree to sign forbearance agreement? 咁剛才我哋講到可能係我哋想同佢整一個協議書、協和書嚇，但係到最後咧佢唔肯簽、唔想簽喎，咁樣又點咧
？So again, you cannot issue a notice at this time during the moratorium. But you just keep your documentation. So if you are communicating with the tenants by phone, be sure to write a confirming email or a confirming letter afterwards to repeat what you discussed. So that can be later used if you have to do a non-payment of rent case. So right now, there's nothing really you can do to force them to sign anything, but it's important that you keep copies of all your documentation in case you need it later on.
咁即係話其實最好嘅方法都係，如果你整咗一啲協議書啊，或者當係一個欠單啊咩都好，你都 send 俾個租客先，佢唔簽咧就都冇辦法嘅，都唔應該係逼佢簽或者係叫佢簽嘅。咁但係咧你就自己有一個記錄，其實咁樣就係最好嘅。咁 Tiffany 喺呢個時候咧係唔係一個啱嘅時候可以發出 pay or quit 嘅通知咧，即係交租或者放棄住喺呢一度嘅通知書俾個租客黏喺佢門口咁。咁而家可唔可以咁樣做咧？
No, not right now. So you cannot serve any evictions right now during the moratorium. You will have to wait until the moratorium expires. But for the non-payment, remember they have 6 months to pay. So technically you cannot serve a non-payment of rent until after this 6 months.
所以喺未來嗰6個月咧，我哋就唔可以俾個 notice to pay or quit 俾佢，即係唔可以俾張紙話你如果交唔到租咧，你就要離開啦。咁呢一啲通知咧係唔可以喺而家發出嘅，點樣都要係等將來嗰6個月嘅。咁 OK。What about after 6個月又會點咧？即係6個月後佢都係冇交租啦，咁應該點樣追翻過去嗰6個月嘅租金咧？有冇得追嘅咧？
So after 6 months, you can issue the 3-day notice to pay rent or quit. If the tenants do not pay within the 3 days, then you can start your eviction lawsuit with the court to try to get that money back or to get them to move out. At that time, most of these cases will settle in some sort of settlement agreement. If you do go to trial, the trial can result in getting the unit back, and it could be money judgment for the money that they owe you.
咁6個月之後咧，如果你嘅租客咧依然係唔交租咧，你到期時就可以發出呢一個3日內搬遷通知書俾佢哋，要佢哋3日之內咧就搬離呢一個物業㗎啦。 咁咧，如果佢哋係冇反應嘅咧，我哋都喺呢個時候都要通過法庭啊，去等法庭去即係你要開始一個訴訟，去等法庭去判，因為佢唔交租喎，咁樣咧就等法庭係頒布係可以驅逐呢一個租客出去你嘅物業嘅。咁如果喺嗰個時候佢都係冇喺嗰個時候嘅話咧，咁你要同你嘅律師商量下，究竟你係跟住佢追住佢個人嚟叫佢還翻賠償翻過去嗰6個月嘅租金啊，定淨係同佢做一個大家即係佢離開個物業嘅協議啦，係咪咁啊 Tiffany?
Yes, that's correct.
Okay.
There's a question about getting the back rent through small claims or judgments against the tenant. Olivia, do you ever do small claims, or would you have a judgment against the tenant during the eviction proceedings?
So if you actually had to go through an eviction lawsuit with the tenant based on non-payment of rent, the issue of what the tenant owes the landlord for the rent is actually going to be decided in that eviction case. As Tiffany mentioned, a lot of them settle. So the landlord and the tenant are going to have a settlement agreement saying what the tenant owes or doesn't owe. But if it doesn't settle, then the court is actually going to make a decision in the eviction lawsuit for non-payment of rent as to how much the tenant owes, and will actually give a judgment saying what the tenant owes.
Tiffany, 咁我哋又繼續啦嚇。
Okay.
唔知道問到邊個問題。
There's a question about owner move-ins. So an owner move-in is a 60-day notice for an owner who wants to take back one unit to live in for him or herself or a qualified family member. An owner move-in right now is not possible because of the shelter in place as well as the eviction moratorium. But you can serve a notice soon after the shelter in place. But remember the statewide rule about the summons. You cannot receive a summons until 90 days after Gavin Newsom declares the state of emergency is over. So even if you served a 60-day notice now, after it expires, you're not going to be collecting any rent, and you're going to have to wait to start your eviction lawsuit until 90 days after the state of emergency ends.
OK， 好啦，Janice 你可唔可以翻譯一下？我而家要行開一陣先。Janice， 請問你可唔可以翻譯一下剛才我哋繼續 host 落去嚇？
有好幾個電話又進來，那我不跟你談了哈。有個人打電話進來了，這個 Zoom meeting 還沒有 finish。
Oh, sorry, I was on mute. I was asking, how long does a typical unlawful detainer take, and how often do people actually go to court to get a judgment versus settling with the tenant?
So you have to go to court if you serve a notice and the tenants don't move out. So it's actually very rare that they will receive a notice and move out within 3 days or within 60 days. So going to court is very typical. And then in the process of going to court, most landlords and tenants will engage in settlement negotiations, because your alternative is taking the case to trial, which can cost a lot of money for both the landlord and the tenant. So it is very common to go to court and very common to then settle in court.
頭先 Stephanie 咧就話好普遍要上法庭嘅，一般咧你俾咗一個3日 pay or quit 咧，啲人就唔會3日搬走或者60日搬走嘅。咁你上到法庭之後咧，佢哋就會好多時都會做一個 settlement， 你屋個 landlord 同埋個 tenant 會 settle 嗰個 case 咯。
And you were asking about how long a typical unlawful detainer takes. It's hard to say because fault-based evictions can be so different from non-fault-based evictions. But because all tenants have the right to an attorney, no matter their income, it generally does take about 3 to 4 months at least once you file the eviction lawsuit.
嗱，一般一個 unlawful detainer 咧就要大概3至4個月，因為每一個住客咧有權力揾到一個免費律師。
Olivia, I'm going to read out the next question for you. Can we terminate the lease due to impact of COVID-19? If we terminate the sublease, can the landlord go after us and or the guarantor? What is the worst case scenario if we are forced to shut down because of no money to pay rent and continue the business? What are the steps if we need to terminate a sublease? I think this question is referring to a commercial business.
Yeah, I think it is as well. So the rules that are in effect right now relate to landlords terminating tenants' tenancies. There are not any rules in effect right now that give tenants outs of contracts, or ways to break a contract right now in the current laws that are in effect. That being said, tenants should look at their lease agreement because, especially with commercial leases are usually fairly complex, and basically landlords and tenants try to think about and anticipate situations kind of like this happening. So there might be some, not necessarily COVID-19, but just, bad things happening, basically, whether it be a fire or some sort of other natural disaster or whatever. There may be provisions in the lease that would allow the parties to break the lease early in the event of some kind of disaster like that. So the tenant would need to look at the lease and see what that says. And then from there, I think, again, this is where negotiations are important. So the landlord and the tenant may want to enter into some negotiation so that everybody can try to come up with the best resolution possible for the circumstances.
喺而家目前嘅法例咧，只有話租客唔交租，咁個業主咧就叫個租客離開嘅啫，就好冇因為呢個疫情嘅關係咧而有任何條文咧俾租客自己話唔因為呢個疫情所以我唔租啦咁樣，就冇嘅，暫時就冇呢一個法例係咁樣去保障啲租客啦。咁租客可以睇返自己本身嘅 lease agreement 啦，即係喺佢嘅租約上面咧可能會有寫明，如果生意不佳或者因為其他嘅天災人禍其他嘅因素而令到生意做唔落去咧，係有啲乜嘢嘅可能性係可以係離開呢一張合約。如果冇寫明呢一樣嘢咧，其實係好應該同業主去傾下所謂嘅 negotiation， 即係大家去協調啦，去傾嘅時候，可能譬如睇下對方可唔可以話減一部分租啊，咁可以傾出一啲咩結果出嚟啊，咁就為之係而家目前唯一嘅方法啦。Yes, Olivia, thank you.
And there was another question there too at the end about what are the steps we need to take to terminate a sublease. And assuming that we're also talking about a commercial lease and a commercial sublease, the commercial eviction moratorium does say that it applies to subleases as well. So basically the same process we talked about with respect to the steps a landlord would need to take when dealing with their commercial tenant. The master tenant in the commercial tenancy would need to take those same steps with their subtenant. And if the subtenant can document that they cannot pay because of COVID-19, then the master tenant is not going to be able, unfortunately, to terminate their subtenant.
其實咧，主房客啦同次房客咧，佢哋嘅角色咧同埋擁有嘅法例咧，其實而家係一樣嘅，咁又冇分話係唔係個 sublease。因為其實如果你遇上係你租金交唔到嘅問題咧，我諗最好就係你應該要同你個主房客去傾，然後主房客去同個業主咧去bargain 個可唔可以話喺租金方面或者其他方面有少少走盞啊咁樣。係。OK， 大家仲有冇其他問題啊 ？Any other questions?
I guess in the meantime, while we're waiting for any other additional questions, do you guys have any suggestions for residential landlords at this time dealing with, I guess, non-paying tenants or any other suggestions based on our COVID-19 situation?
Yeah, I mean, I think right now the main takeaway is really try to work it out. Try to talk to your tenants, try to get them to pay anything on a payment plan. Again, keeping in mind that the rent isn't forgiven. They're still going to have to pay it, and maybe encouraging them to make even small payments to you on a payment plan is going to be better than nothing for both sides. I mean, the tenants don't want to dig themselves into a giant hole because the landlord's going to be able to evict them eventually if they can't pay that rent. So just trying to encourage them to pay what they can as they go along. I don't know, Tiffany, do you have any?
Victoria, do you want to translate that?
Oh, Janice， 你 translate 啦。
佢Olivia 話呢個時候咧，你就要盡量同你個住客傾咯，俾到幾多錢就幾多錢。因為如果佢唔俾個租金咧，佢都係爭你嗰個租金個數目，所以after 6個月佢都要俾翻嗰個數，and 你有權力去踢佢走咯，or 做一個 unlawful detainer。
The other thing,
go ahead.
I would just say, you know, if we talked about owner move-ins today, we talked about Ellis Act evictions, we talked about a lot of different things today, and even though landlords can't necessarily start that process right now, if they're thinking about doing those things, I would really recommend that they reach out to an attorney now. So that way they can start getting the information that they need and learning about that process now so that they can prepare for it later. I do expect that once these things start to shift and the courts do reopen and evictions can proceed, things are going to be very busy. So it kind of starting to get that framework in place now so that the landlords can kind of be the first in line back into court when things start to get better is going to put them, again, it's going to put them at the front of the line.
Victoria, can you translate that?
我打緊字㗎嘛 ，OK， 你 translate 啦。
如果你需要任何嘢咧，雖然呢家個法庭冇開門咧，你都應該開始揾個律師，因為遲啲咧啲律師都會好忙嘅，咁你會準備晒啲嘢先咯。
And we've heard from clients and landlords right now where the tenants, they either are interested in a buyout because due to everything going on, they need to move out of the Bay Area, or they have seen a bigger unit for cheaper rent right now. So they want to break their current lease to move to a bigger unit. And so if you negotiate with your landlord or with your tenants to a simple move out agreement, even if you're not paying them a buyout to leave, you know, it's best to just let them leave. And then you can later re-rent to someone else at a different rental amount.
咁如果係有一啲租客見到佢哋而家用同樣嘅租金，可能可以租到大啲嘅地方，或者想去第二度嘅地方住，咁咧Tiffany 咧就提議大家咧就俾佢哋走，即係就咁。雖然佢哋係冇完成佢哋合約嘅期間，但係咧都係放佢哋走咧係一個好嘅方法，好嘅策略嚟嘅。係，仲有冇其他補充咧 ，Tiffany？
I think that's it. Always the number one rule for any landlord is make sure you have landlord insurance in case anything were to ever go wrong. We do have a lot of clients who have homeowners insurance because they live in one unit and rent out the other. And that is the incorrect kind of insurance to protect you in any landlord-tenant case. So make sure you have a landlord protector policy in case anything were to ever go wrong.
咁 Tiffany 咧就想提醒大家咧，記得係擁有呢一個業主保險，即係作為一個業主啊，作為你係有租客嘅話咧，你就要購買一個業主保險，叫做 Landlord Policy， 係一個現疏嚟嘅咁。Let me go back a little bit, Tiffany. What if 譬如係一個自己住樓上，樓下有租客。咁佢即係等於一半係 homeowner policy， 一半係 landlord policy 嘅啫喎，咁應該點樣買保險咧
？So yes, you need one homeowners for upstairs and one landlord policy for downstairs. And
話需要買兩個啦，你需要一個 homeowners 嘅 insurance policy 係俾自己住樓上嗰一層啦，咁樓下一層咧就要買一個landlord policy 係業主保險嚟保障，因為你係樓下係有租客噶嘛。So in this case, Tiffany, shall them purchase it in a separate, different insurance company? Because most of the insurance company only let you pick either you want the landlord policy or the homeowner policy. They won't split for you half and half. 可唔可以分開兩間買咧
That's correct. You should probably talk to two different companies.
係啦，最好咧就係 Tiffany 話咧分開兩個保險公司嚟購買，一份 landlord insurance， 一份就係 homeowners insurance 咁樣咯。咁我哋仲有冇嘢補充咧？
係我係 Ellis， 我有問題。Olivia, in that case, you suggest that we should have two policy. Do you mean that, say that I have a single house and I'm renting out an in-law, then owner occupy the main house and have tenant in the in-law. In that case, then I have to buy one homeowner's insurance, say that from ABC insurance company, and then to get another coverage, say that rental property coverage from another insured carrier. Is that right? That means I'm double insured for one property.
Tiffany, did
Will
you?
the insurance allow? Because usually they won't allow double insurance, even though the coverage may be different.
Yes, so with a lot of our clients, that is the case because there are so many in-law units in San Francisco. You do need to get a separate policy because the insurance that protects you in your own home upstairs will not protect you against any claims if the tenant were to sue you for any reason, especially if you have an unpermitted in-law unit. You have to get insurance. You have to get landlord protector insurance for the in-law unit. So whatever you need to do to get that coverage.
Anything else you guys like to add, Olivia or Tiffany, that we may not have covered?
I don't think so. Oh, actually, there's one other thing that I wanted to add. You know, obviously right now with everything that's going on with COVID-19, that's kind of in everybody's immediate minds. And And I know a lot of you are probably San Francisco landlords, so this may not impact you for properties here in San Francisco. But I actually just gave another webinar earlier today on California statewide changes to landlord-tenant laws that went into effect before all of this happened. So it's also just important, especially if you have properties outside San Francisco, to keep updated on the changes in those laws. There were a lot of changes that went into effect at the beginning of this year, including passage of statewide rent control and eviction control for most properties throughout the state of California. So if you've got properties outside San Francisco, again, we primarily talked about San Francisco today. If you've got properties outside San Francisco, just be careful too that you're checking in on all the updates to those laws and seeking advice from an attorney about that too, if you're trying to terminate any of those tenancies.
係啊，咁啊 Olivia 話咧，今日主要嘅答案咧都係假設物業咧係喺三藩市嘅。如果你嘅物業或者你嘅租務係離開咗三藩市其他嘅城市咧，其實最好都係向律師樓諮詢。咁因為咧今日嘅節目咧未必係答得晒所有嘅問題，因為佢要知道你本身個問題嚟自係啲乜嘢啦。咁所以其實真係最好咧，就係將整個 case 原原本本咁樣俾律師樓知道，咁佢哋先至能夠話答你嘅答案咧係一定係作準嘅嚇。咁樣咧就Tiffany， 請問你仲有冇其他嘢補充啊？如果唔係，你可唔可以話俾大家聽點樣可以聯絡到你啊
？I think that's it for today. Again, feel free to contact Olivia and I if you have any questions about San Francisco properties or any Bay Area counties. You can email us or call us for a free 20-minute consultation. We are open during this shelter in place, so we can definitely speak to you by phone. And I'll go ahead and type in again our email address as well as the office phone number so that you have our information available to you.
請問你可唔可以將你公司嘅中文名稱都話俾我哋嘅觀眾聽啊？
我哋係麥唐立事務所，就如果你係需要講中文嘅，我都 OK， 不過唔係講得幾正，就我哋都有其他人都可以幫我哋翻譯嘅。
OK， 咁今日時間差唔多噶咯喎，好多謝 Olivia 同埋 Tiffany 嚟到呢一度啦。咁咧今日嘅意見咧，即係事務所俾出嚟嘅意見咧，請大家以英文為作準，因為咧我覺得咧我唔係咁熟法律咧，始終或者咧我係翻譯得唔係咁好嘅，所以一切咧都係會以英文為準。如果我漏翻譯咗一啲嘢咧，大家可以重複睇翻英文嘅版本。咁英文嘅版本咧，聽日咧就會放上我哋美國華人實業協會嘅網誌。所以如果想再聽多一次，重溫翻剛才律師團隊俾出嚟嘅答案，可以去到 www.creaausa.org， 咁嗰度咧就會睇翻我哋過去嗰3個小時嘅 workshop 嘅錄影係會有喺我哋嘅 website 嗰度嘅。咁好多謝大家今日嚟參與。我知道咧，因為我哋由2點開始咧，所以可能我哋觀眾有少少攰啦。咁好多謝你嚟啦 ，Tiffany。咁咧，我哋咧有問題咧係一定會打電話俾你或者係 email 俾你再詢問嘅。好多謝大家，節目時間夠啦，拜拜。Thank you very much.
Thank you, everyone.
Thank you so much for having us.
Thank you.
Thank you, Tiffany. Thank you, Olivia.
Thank you.
Thanks.
Bye bye.